alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are, as long as they are related to the English legal system, please feel free to ring on the number that appears at the bottom of the screen. Alternatively, you can send a message, a WhatsApp message or a text message on the mobile number that appears at the bottom of the screen. Now, it's understandable that legal questions, legal queries, sometimes they are quite confidential and sensitive, and people don't necessarily want to come on air live and discuss their confidential matters. So a fantastic, easy way for you to contact us is to simply send us a WhatsApp message on the mobile number which appears at the bottom of the screen. A couple of minor points before we get going. Obviously, on a live show, sometimes it's difficult to take very detailed information from callers who call in. And if that's the case, if your matter is complex, then I'll ask you to leave your number with the control room and then I will give you a ring off air. Secondly, sometimes I need to look at documents before I can advise you properly. This happens with immigration law matters, particularly where somebody's made an application for a visa and their application's been refused and they want you to look at the refusal letter, or I need to look at the refusal letter to give proper advice. So if it's the case that I need to have a more in-depth discussion with you, or I need to look at your documents before I can advise you, then I will ask you to leave your number with the control room and then I will call you back and we can arrange to have a more thorough discussion off air. So if you want to speak to me live on air, the number that you can call on is the landline number, and to send me a message, it's the mobile number. Now, we've had a number of questions that have already come in just as we were about to start. A number of questions on WhatsApp. Let's look at some of those questions. Let me read the question out first and then let's have a look at what the position is. And if it's the case that after I've answered the question, you're still not clear about the answer, you're still not clear of your options, then please feel free to give me a ring or send me a follow-up question. That's no problem at all. Okay, let's look at the first question that's come in. Dear sir, what does my partner need to apply for after our marriage, as we will be getting married soon, hopefully in the next few months, but he will be going back as we have children in education. Do we apply for a spouse visa? Do we apply for a family visa? Which visa is it that gives the possibility of working, as we don't want to be dependent on the system? I think it's meant by the welfare state in the United Kingdom. So our viewer is asking, what kind of visa does one apply for after the marriage has taken place? In this particular case, the spouse is going to be going back to their home country. I think there's some child care issues there. That's why they may need to go back temporarily. And the question really is, which visa is it that you apply for? Now, if you go on the Home Office website, it's termed quite differently. Some references are to a spouse visa. There are some references to a family visa, some references to a partner visa. The actual immigration rule refers to the visa as a 5-year partner visa, an application which is being made from abroad. But when you are searching for the online application, you can search for spouse visa, 5-year partner visa. But if the application is going to be made from abroad, you need to make sure that you select the correct option where you're applying for this partner visa from outside the United Kingdom. So in terms of the visa, the actual correct term under the immigration rules is it's the 5-year partner visa, sometimes referred to in the rules as an Appendix FM partner visa. So it's basically the spouse visa that your partner comes on to come to the United Kingdom. Now, if you're married, and I'm assuming you're a British citizen or you've got indefinite leave to remain in the United Kingdom, you simply want to sponsor your partner to come to the United Kingdom on a long-term basis, that is the best visa to apply for. That visa has with it the right to live in the UK, obviously, and it also has with it the right to work in the United Kingdom. And in addition to that, you're able to access the NHS as well. So with that visa comes the right to work, comes the right to live, comes the right to have access to the NHS. So for you, if potentially in the future you're looking at your partner coming to the UK to settle with you, or you're both going to come to the UK and settle here, it is that visa that you should go for. The problem with other visa categories in this situation is that it doesn't really provide you with a solution in terms of what you're looking for. A visit visa is simply a short-term visa, so it doesn't really help you as such. After 6 months, your partner has to go back. You can't settle here on that. A student visa, again, is not very helpful because it's for the limited duration that somebody is studying. In your particular situation, if you're getting married, assuming you're British or you have indefinite leave to remain, the correct visa category is the spouse visa, appendix FM visa. So that's the visa that you should be applying for. Now, a couple of points before we get going. Obviously, with that visa, there are some very strict requirements that need to be fulfilled. The main requirement is going to be the financial requirement. So you need to address your mind to that. That if you're the British citizen, are you in the United Kingdom with a job from which you're earning £18,600 per annum? Can you show that you've been employed for 6 months? Or are you going to meet the financial requirement in some other kind of way? Are you going to show self-employed income? Are you going to show your savings, etc.? So although the correct visa category is this partner category, the main issue that you will need to address is how do you meet the financial requirement? Now, from your question, it does look to me like both of you might be initially considering living abroad and then coming back to the UK together. That's all well and good, but it would mean that you're not in the UK earning, meeting the financial requirements. So no, you do need to address your mind to what you will be doing as far as the financial requirement is concerned. Is it the case that you've got sufficient savings so you don't need to show employment, or you've got sufficient income from a business which is operating independently? So you need to look at the financial requirement. As long as you get that right, in my experience, the other requirements are not particularly difficult as such in order to qualify under the spouse appendix FM route. Hope that answers your question. If you're not sure, as I said before, please do feel free to send me a follow-up question on WhatsApp, or please feel free to pick up the phone and give me a ring if you think I've not answered your question properly or you've still got additional queries. But thank you very much for that. Okay, a number of questions have come in. Let me go on to the next question, slightly different question. Our viewer who's sent a WhatsApp message says, Salam, Brother Ilyas, I have to pay £3,303 as child benefit charge because my annual income exceeds £50,000. Is it possible for me to deduct the NHS pension contributions from my income? On their website, using the child benefit calculator, pension contributions are classified as allowable expenses or allowable deductions. Could you please advise? Interesting question. Just before we were coming on, we were about to start the show, what I did do is have a quick look at the rules on this so that I could give you some definitive advice. So our viewer who's texted in is on a salary which is above £50,000 and is working for the NHS. Now, the position for somebody who earns above £50,000 is that if they are in receipt of child benefit, then they would have to either pay all of the child benefit that they've received back, or they might have to pay part of it back if their income exceeds £50,000. Now, specifically, what our viewer is asking here is really to look at how we can get the income below the £50,000 mark so that the child benefit charge doesn't apply. Now, the point you make is entirely correct. If you are making pension contributions, whether it's to the NHS pension scheme or it's to a personal pension scheme, these are allowable deductions. So let's say, for example, your salary is £55,000 a year and your contribution to your pension scheme, whether it's the NHS scheme or it's a private scheme, is £5,000, £6,000, whatever it is, that is then deducted from your salary. So the net figure that you're left with is the figure after you've made your pension contributions. There are other payments that can be deducted. I think charitable donations can be deducted. So there are certain payments which you've made, mainly pension contributions, that comes off your gross salary. And the net figure that you're left with is actually the figure that you look at in order to work out whether the child benefit charge applies to you or not. Hope that answers your question. Just on that point, a minor point, my understanding is if your income is between £50,000 to £60,000, there is a scale that they use to look at how much money you need to give back, what the child benefit charge is. It may well be that you don't have to pay the whole amount back. There's a sliding scale there. The less you earn, the less the charge is. I think the bigger problem is if your income exceeds £60,000, then the child benefit charge kicks in. But in answer to your question, specifically, pension contributions can come off your gross salary to work out the figure, which is then subject to the child benefit charge. Hope that answers your question. We've had numerous questions coming in on WhatsApp. We're going to be taking a short break soon. Once we come back, I'll look at some of your questions coming in. But as always, please do send us your questions and we'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, you can call on the landline number which appears at the bottom of the screen. And as always, if you want to send us a message on WhatsApp or you want to send us a text message, please feel free to do so on the mobile number that appears at the bottom of the screen. We've got a number of WhatsApp messages that have come in already. Let's look at the next question that's come in. Interesting question, quite a technical question that's been asked here. Let me read the question out and then let's address the issue that's been raised. Our viewer asks, my wife came to the UK as a Tier 1 partner and then got further leave to remain under the 10-year route. So comes as a Tier 1 partner, then later on gets further leave to remain under the 10-year route. Initially, the visa was granted for 2.5 years. She has now been in the UK for 6 years. Does any of the past 6 years count towards indefinite leave to remain based on the 5-year route or the 10 years long residency route? Okay, slightly complicated. What our viewer is asking is in relation to the partner who initially comes to the UK as a Tier 1 partner. So the main sponsor here would have been on a Tier 1 visa, probably an entrepreneur visa, investor visa, a business type visa of that sort. So the partner joins, the sponsor in the United Kingdom initially gets a Tier 1 partner visa, all well and good. And I think at some stage, for whatever reason, the partners then switched visa category. So the partners come out of the Tier 1 partner category and gone into the further leave to remain category. And I suspect what's happened is that the main sponsor has managed to get indefinite leave to remain, and that's why the partner is now being sponsored under the further leave to remain category as opposed to the Tier 1 category. Now, the position is this. Partner has now spent 6 years in the United Kingdom. Those 6 years, do they count? What do they count for? Easy way to deal with it is this. Those 6 years, I'm assuming that throughout the 6-year period, the partner was completely legal, there wasn't any period of overstaying, in which case the 6 years do count towards the 10 years long residence. So for the 10 years long residence, what you need to remember is this, that long residence, legal long residence, can be made up of different types of visa. Here, the partner came to the UK on a Tier 1 partner visa, then assuming they moved on to the 10-year further leave to remain route, you can combine the two visas together, and that gives you 6 years of lawful residence. Your 6 years of lawful residence counts towards the 10-year long residence category. There would obviously still be another 4 years that the partner would need to do. So I suspect the partner would need to continue extending under the further leave to remain category, what the 10-year route that the partner's on. You get to 10 years from when they came into the United Kingdom. At that stage, the 10-year long residence category is satisfied. So in that sense, that's fairly straightforward. The 6 years do count. The different categories can be combined. What you can't do is use the 6 years for anything else. So currently, the partner is on the 10-year route to settlement. So what you can't do now is use that previous category, which had the label 10-year partner route on it, and say, look, you know what, you've completed 5 years. Can we just apply for indefinite leave under 5-year partner route? You can't do that. To qualify under the 5-year partner route, the visa that you've held in the previous years, they must have been for the whole period of 5 years under the 5-year partner route. So you must have held the 5-year partner route visa. You must have completed 5 years under that for you to be able to qualify for indefinite leave to remain under the 5-year partner route. If that's not the case, then to me, it looks like we're heading towards the 10-year route, the 10-year long residence. You count your 10 years from when you entered the United Kingdom. 10 years on, you've got these different types of visa, Tier 1 partner, further leave to remain under the 10-year partner route, whatever else there is, count it all, put it all together, and after 10 years, you qualify for indefinite leave to remain. So that's how it works. It's not too bad. There's only 4 more years to go. You've done more than half. So hopefully that deals with that. Again, if you're not sure, please do pick up the phone and give me a ring. Understand that's a slightly complicated query. Okay, we've had a number of other questions coming in, but if you want to give us a ring live on air, please feel free to do so on the landline number. But as always, please do send your question in on WhatsApp. We're getting some technical difficult questions in today. So let's look at the next question. The question is from a viewer from Bristol. My question is for Mr. Ilyas. Assalamu alaikum. Hope you're well. 2 questions. I am on a Tier 2 visa. My 5-year visa will be completed on the 10th of December 2021. So the 5 years are completed on 10 December 2021. The current visa actually expires on 12 November 2021. Can I apply for indefinite leave to remain on the last day, when I'll be 28 days short of the 5 years in the United Kingdom? Okay, so the 5 years are about to come up. Unfortunately, the visa expires exactly 28 days before. Can you make the application 28 days before when you've actually not completed 5 years? Now, the position is this. You can actually apply 28 days before, even if your visa finishes 28 days before, so you don't have that 1 month left. Now, the reason I say that is I've actually done that before on a long residence application, where the full 10 years weren't going to be completed. They were about to be completed, but the visa that the person was on was going to expire 28 days before the 10 years were going to be completed. We did submit the application. There's nothing in the rules which says you can't submit the application. The rules simply say you can submit the application 28 days before you complete the period, submitted the application 28 days before, even though the person didn't have enough visa to carry them through to the end of the 10-year mark, the application was granted. And I did look at the immigration rules properly at that stage. There's nothing that says that when you apply, there has to be enough visa to get you to the end. So my personal view is you can make that application as long as it's no earlier than 28 days before. Hope that answers the question. Let's take our next call. Hello, Assalamu alaikum.
Hello, Assalamu alaikum.
Ji walaikum assalam. Ji bhai, thank you for calling. What's your question?
My question is that I have an indefinite stay since 1988.
Okay.
But I never applied for British citizenship because I had a brain injury and I went into a mental institution. Now, it was at that time the rule was you have to be sound mind.
Yeah.
But before my brain injury, my status of my financial situation was very, very poor. Now, if I wanted to apply now, can I qualify, even have a brain injury for British passport? Because my all children were born here, and since 1986, it's a long time.
No, I completely understand. Look, in terms of the issue about sound mind, that requirement is still there in the immigration rules. Now,
oh my God!
But to be quite honest, look, sound mind. What is it when they refer to sound mind? And again, this is something I've had to look at in depth. Sound mind really is the Home Office looking at whether you understand what you're applying for. So it's not the case that if you've got a mental illness, you are then barred from applying for nationality. The requirement in relation to sound mind is simply this, that you understand what application you're making. You understand that you're applying for nationality. That's what the reference to sound mind is in relation to nationality. Look, we've had this conversation. You clearly understand what the issue is. So as far as you're concerned, you shouldn't be worried at all about the sound mind category. We've had a very normal conversation. You completely understand what's going on. You put your question to me very clearly. So don't worry about that. There's no specific question on sound mind either when you actually fill the application form in. You fill it in, you know what you're signing, that's fine. Now, you just need to make sure that the other requirements are satisfied in terms of, your residence in the United Kingdom. Have you been living in the UK for the last 5 years?
Yes.
Okay, so and then if you've had short-term absences, that's not a problem. But if you've generally lived in the United Kingdom, you'll be okay. In the last year, you're allowed 100 days out of the UK. In the last 5 years, you're allowed around 450 days outside the UK. So as long as that's fine. Now, the other requirement is that you need to.
And in the past, if there was a problem of before my brain injury, your business goes collapse and all, you had county court and you divorce and all. Does that count as well?
No, that's not a problem. What they can look at, that comes to character. There's a good character requirement. Where
I don't have any criminal record.
So fantastic. I didn't want to ask you that live on air, but you've answered the question.
It's only parking. Parking tickets and all, but I didn't have any criminal.
We're all guilty of that. We all try and get away with that. So look, hopefully there's no issue in character, but you do need to look at if there are in the last 10 years, if you've become bankrupt, you need to be a discharged bankrupt. So as long as you've been discharged, it's fine. If there's money, if there are county court judgments against you, if you're paying them off, again, it's fine. So your personal financial situation normally doesn't prevent you from getting nationality. It may only prevent you if you're an undischarged bankrupt. Then that might be a problem.
Yeah.
So
I don't.
From what you're saying, sound mind isn't an issue, absences isn't an issue, and I think good character isn't an issue. The only other thing that you need to bear in mind, and I can tell that that's not a problem, you will need to get the English certificates. So the B1 test in English and the life.
Although I'm dyslexic, I speak very well, but I have no concept of writing full stops and I can't write.
All right.
But I can speak very well.
Right.
Yes,
so the B1 test is just simply speaking and listening. There's no problem you getting that. There is the life in the UK test you need to do as well. So you do need to get the life in the UK test done as well. Now, if it's the case that because of your illness, you're not able to do a test, you can apply for an exemption. Your doctor would need to complete a medical exemption form. But my view is if you can get the B1 test done, if you can get the Life in the UK test done, by all means, get that done first. Hope that answers your question. Going to be taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, you can call on the landline number that appears at the bottom of the screen. To send me a message with your question, with your query, you can do so on the mobile number that appears at the bottom of the screen. Just before we went for our break, we had a brother from Ipswich who was on the phone. Hopefully, I did answer your question properly. The point I was making was that you shouldn't worry about making the nationality application. And certainly don't worry about any illnesses that you've had in the past, or even if you've got a mental illness now, that's not a bar to applying for nationality. And I was just dealing with the English requirement as we finished. Our brother from Ipswich did say that he had dyslexia. I don't know whether that causes any problems in doing the Life in the UK test. I mean, hopefully it doesn't. But if it does, two things I should make. It may be that you can speak to the organisers of the Life in the UK test to see whether any adjustments can be made for you to make it easier for you to do the Life in the UK test. If there are any reasonable adjustments that can be made because of your disability, they are under an obligation to do that. So that's one point. If not, you could get a medical exemption to get over that hurdle. Okay, let's take our next call. Hello, assalamu alaikum. Hello. Ji walaikum salam. Ji bhai, thank you. Hello, thank you for calling. What's your question?
Yeah, my question is, I have a refugee status. I live to remain, and it's to expire on the 12th of December 2021.
Okay, okay.
So, yeah, I was asking whether can I apply for indefinite leave to remain in October, like a month or 2 months before 12th December.
So I just wanted to check, and I think you have answered that in the question that you sent in, that your refugee visa was for the full 5-year duration, wasn't it?
Yeah.
Because sometimes the Home Office, certainly recently, they seem to be granting refugee visas for 4 years, but yours is for 5 years.
Yes.
Okay, all right. Now, that being the case, you can apply early, but you can't apply any earlier than 28 days before you complete the 5 years. So if your 5 years, if you got the initial grant, the refugee status in December, your 5 years would come up in November, 28 days before. You wouldn't be able to apply any earlier than that. So you'd need to work out what the date is 28 days before your 5 years come up. So for example, if the 5 years come up on the 30th of December, 28 days before would be on either the 2nd or the 3rd of December. So that would be the earliest. You couldn't go further back. You couldn't go into November or October in that situation. You can only apply, the earliest you can apply is 28 days before. The latest you can apply is the last day on which your visa expires.
Okay.
Does that answer your question?
Yeah, thank you. Yeah, it does.
Okay.
Thank
No
you.
problem at all. Thank you very much for your question. Thank you very much indeed. And you know, it's similar to a number of other questions that we've had coming in. When can you apply for visa extensions? When can you apply for indefinite leave to remain? Normally, the earliest is 28 days before, but there are exceptions to that. In certain circumstances, you can apply. But what you've got to remember is this, that the visa category that you're applying under, if it requires you to complete a certain number of years, refugee status, you need to complete 5 years. The 5-year partner route, you need to complete 5 years. So where there's a requirement that you need to complete a certain number of years, then the earliest you can apply is 28 days before you complete that period. So if it's a visa where it's imperative that a certain level of residence is required in the UK, the earliest you can apply is 28 days before that residence requirement is completed. Hope that answers that question. Now, previously we received a question which I answered in relation to somebody who is on a tier 2 visa, sister from Bristol who sent that question in. Now, and what I advised was you can apply 28 days before your indefinite, before your 5 years are completed, which is absolutely fine. I understand that there will be a slight gap when your 5-year tier 2 visa wouldn't be completed over 5 years. It would come to an end when you make the application 28 days before. That's not a problem. The follow-up question that you did ask, which I wasn't able to answer, is do you recommend I should first apply for an extension and then apply for indefinite leave to remain after the whole 5 years are completed? I didn't get time to answer that question. Now, the answer to that is no. As long as you are about to complete your 5 years within the last 28-day period of your visa, apply for indefinite leave to remain. Don't apply for an extension. The problem with applying for the extension is that you will need to pay an application fee, you will need to pay an NHS fee. That will set you back in the region of just under £2,000. There's no need to do that. When you apply for indefinite leave to remain based on your tier 2 visa, you will be submitting a letter from your employer. That letter will confirm that your services, your employment will continue after you've got your indefinite leave to remain. You're needed by the employer. That is sufficient. The Home Office can tell that although your visa is coming to an end, you are required by the employer and you will be able to get indefinite leave to remain based on that, even though there's a gap of 28 days. There can't be a gap which is bigger than 28 days. So you couldn't apply 29 days before or a month before. The gap can be no bigger than 28 days. So that being the case, my view is you should apply for your indefinite leave to remain 28 days before, and there won't be a problem at all. Okay. Hope that answers the question. We've had a number of other questions coming in. Let's look at them. Quite a long question. Let me read the question out, then let's look at what the answer is. I have indefinite leave to remain, came to the United Kingdom as a refugee. Application was rejected. I think there's a bit of history to this. The application for refugee status was rejected. Our viewer appealed and was successful at the first stage. The Home Office appealed against the decision. Case went back to court and the Home Office lost. So our viewer, luckily, was successful again. So there's a bit of history applying, being unsuccessful, appealing, winning, Home Office digging their heels in, appealing again. But ultimately, what's being said here is that ultimately refugee status was granted, which is fantastic. Now, the question that our viewer is asking is in relation to the financial requirement or looking at employment history. So we've had a number of questions in today, interesting questions on nationality today, on sound mind, on character, on the English requirement, English language requirement. This question is about employment and somebody who's had sort of a difficult immigration history, no fault of their own, but ultimately their refugee status application was successful. Now, what they're asking is about their employment history, and they're quite candid. Our viewer says, I have no good work history, so there must have been problems with the work history. And they say, I know that the financial and work history is needed for certain applications, EU applications, EE applications, when they're sponsoring family members. That's entirely correct. Now, finances, in particular, whether you've been employed or not in the last 5 years, in the last 10 years. So in terms of your employment history, generally speaking, your employment history is not relevant as far as a nationality application is concerned. The Home Office does not look at what your employment was like. Did you work full-time? Did you work part-time? Were there gaps in your employment? The Home Office is not interested in that. Now, as far as employment is concerned, the Home Office does look at two things, and I'm going to address that next. But in 99% of cases, employment history is irrelevant. So if you've worked, not worked, had gaps in your employment, you don't need to worry. Now, what are the two normal exceptions to this rule? When do you need to take the employment history more seriously? Well, first of all, if part of your residence in the United Kingdom over the last 10 years has been based on you being a European national or you being a family member of a European national, then employment might be relevant. Because if you think about it, European nationals who were in the UK before, I know that we've got the settlement scheme in now, it's all changed, but prior to that, European nationals who were in the UK only had the right to live in the UK if they were working, if they were self-employed, if they were students, or if they were self-sufficient. Most people showed that they were employed. So in order to have continued to live in the UK legally, there would normally have been a requirement for European citizens that they were in employment. If they weren't in employment and if they weren't looking for employment, it could mean that their residence became illegal, unlawful. Now, what the Home Office is doing now, unfortunately, is analysing the residence of European nationals to see whether their residence was lawful or not. Let me take an extreme example. Somebody, a European national, comes to the UK, doesn't work for a year, 2 years, etc. Technically, that residence was unlawful, even though they've now got permanent residence under the settlement scheme. Their residence was actually unlawful because they only had the right to live here if they were working. Now, when you make the nationality application, the fact that there could have been an unlawful period of residence could be used against you. So that's one thing you need to remember. The second thing you need to remember is if you've worked illegally in the United Kingdom, unlawfully, so you've worked when you shouldn't have been working, then that is something that the Home Office could use against you as well, because that goes towards your the assessment of your character. If in the last 10 years you've worked unlawfully, that shows that you are not of good character as far as the Home Office is concerned. So as far as employment is concerned, generally you've got nothing to worry about. But you do need to bear in mind that in certain circumstances, you do need to be careful. If you've been a European national or if there's been a period of unlawful employment, you need to be careful because that could cause problems for you as far as your nationality application is concerned. Hope that answers that question. We're going to be taking a short break. We should be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live in relation to any legal questions that you have, please ring on the landline number that appears at the bottom of the screen. But as always, if you have any questions that you want to send to us on WhatsApp or by text message, please continue to do so on the mobile number that appears at the bottom of the screen. We've got a number of questions coming in. Let's have a look at that. But by all means, if you want to speak to me live on air, please do call on the landline number. Next question that's come in is in relation to a spouse application. What our viewer is asking is that my partner who is abroad is about to make an application to join me in the United Kingdom. They are struggling to find a date to sit their English test, the A1 Life Skills Test. Is it possible to apply for a visa without having done the English test? Okay. This is quite a common question and certainly a question that immigration lawyers were being asked quite regularly during the lockdown. So if you think about it, in foreign countries, whether it's India, Pakistan, UAE, Middle East, etc. When we had the initial lockdown last year, a lot of other countries had a similar kind of lockdown as well. The problem was during that period, a lot of these colleges, a lot of these test centers were closed. So all of a sudden, it was difficult to get hold of certain documents. So certainly, if you think about it, with a spouse application, you would normally be submitting from abroad. You would normally be submitting a TB certificate. So if your husband or wife is being sponsored to come to the UK, there are certain documents that you submit. So a TB certificate from abroad, just to confirm you don't have TB, an English certificate to confirm that your English is up to the required standard. The problem was, certainly during the last lockdown, that all of a sudden it became difficult to get these documents because the clinic where the TB test was being done had been closed. The centre, normally with the British Council, where the English tests were being done, were closed as well. So what the Home Office said, and this is still applicable, that if you are unable to submit a document because it is impossible to obtain it, for example, and there were two examples that they gave. For example, the test centre is closed, or it's impossible for you to get to the test centre because there may be restrictions on travel to the test centre. So what the Home Office said is that in that situation, you will be exempt from the English test requirement. Now, so we did a number of applications where it was impossible for people to get to the test centre because the police in question, the government in question, they'd restricted travel outside one's own city, one's own locality. We made these applications for spouses to join sponsors in the UK. We explained that it's impossible to obtain these certificates. Now, the Home Office did query some of these applications. They wanted to know what was going on. And when we explained that, look, we're not saying the test centre is closed. We're saying that the applicant, the spouse who wants to come to the UK, simply isn't permitted to travel outside their own area. What we did find is that the Home Office did accept that explanation and visas were being granted. Now, there is a particular difficulty here that if your reason for not being able to get the English test certificate is simply that the exams are being postponed, so the test centre isn't closed, the exams are being postponed. So you've got a date in May and what they've said to you is, come back in June, or they've said to you, come back in July. Some caseworkers at the Home Office have taken quite a strict approach. What they've said is, look, our policy is that if the test centre is closed, then you can rely on the exemption. You don't need to do the English test. However, if the test centre isn't closed, the test centre is open, and all that's happening is that you are being given another date to do the test, then you don't fall within the exemption. You must do the test. So the key thing is that what the Home Office says at the moment is if you can't do the test because the test centre is closed, or because you can't travel outside the area, we will allow you to rely on the exemption. So there is an exemption there where you're unable to produce certain documents, but it is quite strictly applied. Now, the other scenario that comes to mind is where the sponsor in the UK is employed. However, it's difficult to get hold of certain documents to prove employment. In particular, it's difficult to get hold of an employment letter. So what's happened with a lot of employers is they've taken the view that in the current scenario, they will only deal with important, urgent matters. If you're raising questions, if you're asking for things which are not urgent because they're short of staff, then those requests will not be dealt with. So we had clients who had difficulty in obtaining an employment letter confirming that they are employed because the employer was simply saying that, look, we're too busy, we're short-staffed, we can't deal with your request for an employment letter confirming your employment. So we did submit applications without that required document explaining, look, this is what's happened. You've got a P60, you've got a contract of employment, you've got wage slips, you've got bank statements. It all corroborates what the sponsor is saying, that they are properly employed. We're not able to get the employment letter. Can that requirement be waived? And to our surprise, the Home Office did agree that, you know what, we accept that there are difficult circumstances here and that that requirement can be waived. So the key point here is this, that if you're wanting to extend your visa here, or if you're a sponsor and you want to sponsor your relatives from your spouse from abroad to come here, and you're finding it difficult to get certain documents, you might be able to rely on an exemption. You might be able to get away with applying without that particular document. So don't be too troubled by the fact that there are some documents missing as far as your application is concerned. You might still be able to apply. What I would advise is that to take advice from an immigration advisor who can advise you properly in relation to this. Another question that's come in on WhatsApp, again, relates to spouse applications. And what our viewer is asking is this. I have been employed for the last 26 weeks. However, I am concerned that my income fluctuates on a weekly basis. Sometimes my wage is quite good and I earn in over £400 a month, but there have been other weeks when work has been quiet and I've earned around £300 a week. Can I still sponsor my partner to come to the United Kingdom? Now, as our viewers will be aware, or anybody who's been through the process of sponsoring a partner to come to the United Kingdom will be aware that there is a financial requirement which needs to be satisfied, and it's normally the financial requirement which causes the biggest problem, the biggest headache. There are quite strict rules around how the financial requirement is satisfied, and it's sort of understandable because the Home Office wants to make sure that if you're sponsoring a partner to come to the UK, you're going to be able to look after them financially. The Home Office doesn't want them to become a burden on the state. So understandably, the Home Office will want to look at your financial circumstances. Are you earning what you say you're earning? Can you prove it in accordance with our requirements as far as documents are concerned? We want to be satisfied that you're earning enough money to be able to sponsor your partner to come to the United Kingdom. And it's that background against which this question is being asked. Now, the specific answer to your question is if you are an hourly paid employee. So the important point here is this, that you must be an hourly paid employee. If you're an hourly paid employee, your income over the 26-week period can fluctuate and it doesn't cause you any problems. What the Home Office will look at is your total income over the 26 weeks. As long as that amounts to £9,300, which is half of the 18,600 requirement. We're looking at this over 6 months as opposed to a year. So half of 18,600 is 9,300. So as long as it comes up to £9,300 over the 26-week period, then it doesn't matter that you've had good weeks and bad weeks. So you could have a week where, as you say in your message, where you've earned £400 a week. You could have another week where your income's dipped and you've earned just £300 a week. That doesn't cause a problem. You can add it all together as long as your income comes up to £9,300. So for hourly paid employees, it's quite helpful. You can look at your total income and average that out. Now, as I keep on saying, that only applies to hourly paid employees. If you're on a fixed salary, that doesn't apply to you, unfortunately. So if you're on a fixed yearly wage, let's say £20,000 a year, the problem you have is to be able to satisfy the financial requirement, you need to consistently earn that amount during the 6-month period. If you're on a fixed salary, you can't have a month where the income drops. So let's say your gross on £20,000 a year comes up to about 1650 gross. You can't have a month where you get only £1,200 because you've taken unpaid leave. Next month, you get extra. That may cause you a problem. It's slightly more complicated if that's the case. The Home Office will generally look at the month where your income's dropped. There may still be a way around it. You might be able to use overtime to bump up your income. But you do need to be careful that if you're a fixed salaried employee, it may be difficult for you to satisfy the requirement if your income's been fluctuating over the last 6 months. That unfortunately brings us to the end of the show. Next week, we'll be back on Tuesday at a slightly different time. We'll be back on Tuesday at 8 o'clock, which is our normal time, 8 o'clock till 9 o'clock. Please join us then. But for the time being, inshallah, we'll see you next week. Until then, Assalamu alaikum.